Welcome to Brief Encounters. My name is Valerie Mirko. I'm a partner at Armstrong, Teasdale, and leader of the firm's Securities Regulation and Litigation practice. And this is episode 6 of the Securities Regulation and Enforcement series. And I am here with my co-host, William Nelson. William, since we last spoke, your title changed, so I wanted to go ahead and let you reintroduce yourself.
Oh, thanks, Valerie. Yeah, it did. So now I'm currently the Director of Public Policy and Associate General Counsel at the Investment Advisor Association.
So congratulations. And we're still continuing the series. This is episode 6, and eventually we'll stop counting, but for now we're still counting. Today's episode is focusing on off-channel communication. Now, usually the point of view of our podcast series is to look at current issues in securities regulation and enforcement through the lens of Dodd-Frank and the Dodd-Frank Act. We're taking a bit of a departure today because off-channel communication is, first of all, such an important topic in our industry for those of us who work with broker-dealers and investment advisors and other parts of the financial services industry. But secondly, this is not really something that would have come up in Dodd-Frank because it goes back to the record-keeping rules, which have been, unfortunately, a little bit stagnant for a couple of decades now. So today, instead of looking at this issue through the lens of Dodd-Frank, we're just going to have a discussion about recent settlements in off-channel communications. Where do we see things going? And just generally our take on this issue. First and foremost, this has been an issue the SEC has focused on for going on 4 years. And at this point, around 100 entities, depending on how you count the settlements, have settled off-channel record-keeping charges. And this includes broker-dealers that are standalone broker-dealers, dually registered broker-dealers and investment advisors, standalone investment advisors, credit rating agencies, and municipal advisors. So this has really been a pervasive issue throughout our industry. I know the dialogue has been how pervasive the use of off-channel communications has been, but really to me, this is just such a prevalent issue. What we wanted to focus on today, however, was a little bit of a state of the union on off-channel communication. We have about 100 settlements to look at. They're not all identical. They have different issues, but we really wanted to talk through some of the key findings and then also focus in a little more deeply on what this means for investment advisors versus broker-dealers. And then finally, talk about 2 recent matters that were settled right at the end of September 23 and 24, because those are notable matters for not having had civil penalties. And we do want to discuss what that means. That sounds positive, but that is not as positive as I think we would like it to be. So, William, you have been following off-channel communications as well through the Investment Advisor Association. What has been your area of focus as an association?
Yeah, so Valerie, I think for, the IA and just, advisors in general, I think traditionally we have viewed the Advisors Act record-keeping rule, that 2042, to be, just generally narrower than the broker-dealer books and records. And when you look at the 2 different statutes and regulations, broker-dealer are required to keep all communications relating to the firm's business as such. And again, business as such can be interpreted in a number of ways. But, you kind of think of the records kept in the ordinary course of business. Then if you go over to the Advisors Act, there's more specific, narrower enumerated categories. Could be, recommendations to clients, receipt, disbursement, delivery of funds, executing orders, certain performance records. So I think from our perspective, we really do see the universe of record keeping for advisors to be narrower than the broker-dealer world. Again, that business as such really versus those several categories of information that need to be kept by advisors. And I think you really did see that too, and how these cases have evolved. It really has gone from the larger broker dealer duly registered folks. And then, it really morphed into we're also going to start looking at investment advisors for these off channel cases as well.
I think that's right, particularly in that there is a difference between the record keeping statutes for broker dealers and investment advisors. Over the last several years of counseling clients on these issues, there's the reality of the fact that the statutes are different, and then the reality of how businesses are run. So, for example, for dual registrants, while those dual registrants are aware of the differences between the record keeping statutes, the reality is they maintain their records all in one place, use sort of a one firm policy across the firm, and as a result, don't always benefit from the fact that investment advisor record keeping requirements are not as broad as broker dealer record keeping requirements. So I think what we're seeing is broker dealers and dual registrants tend to fall under the broker dealer rules in terms of record keeping, whereas investment advisors that are standalone entities are benefiting more from the fact that record keeping statutes for investment advisors are just a little bit narrower than for broker dealers.
Yeah, and those are great points, Valerie. And I think too, to even put a little bit of a caveat on what I said earlier, even though the Advisors Act is written narrower than the record keeping obligations for broker dealers, you still have investment advisors that keep records for risk management purposes, for just other business purposes, for auditing purposes. So, I think that for some of these cases, we do see that, hey, we know what the Advisors Act record keeping provision is, but our policies and procedures went further than that. They either did keep business records or they kept, certain work related messages and records. So I think that is something to, especially for advisors to be aware of, kind of that difference between maybe what the Advisors Act says, but what your policies say.
I think that's exactly right. And depending on the size of the firm, the firm may be smaller and working with more standard policies and procedures as opposed to very customized policies and procedures. What I generally counsel when I'm doing some kind of risk-based analysis, or what my regulatory colleagues will counsel, is to really just take a very risk-based approach on record keeping. The reality is most investment advisors will want to maintain more than what is required, both from a business perspective and a risk profile perspective in terms of understanding all of the communications that are occurring and the context in terms of the additional records they should be keeping. The other thing that I really wanted to bring up is to go back at sort of fundamentally, why is this important? Because I think when you have over 100 matters, some with frankly outsized civil penalties, it's easy to sort of get lost in the, well, this order said that, and this was the amount. And I really like to take it back to basics, which is fundamentally record keeping is important. It's not just because the SEC needs to be able to enforce its rules and have access to records about firms' activities. It's also because firms that believe in compliance, which the reality is most of them do, firms that are serious about complying with SEC rules also need access to their own records about their business activities. They need to understand what is happening in their business in order to supervise it and in order to foster compliance with rules. So what I found really interesting, and we did not have the podcast back in 21, but I think I would have said this back then, the reality is the original off-channel communication cases really arose from a legitimate concern that improper record-keeping practices were impeding compliance efforts, not just in terms of SEC examinations or SEC enforcement, but also just in terms of the day-to-day of in-house compliance work. That was several years ago. And at this point, first of all, the industry has gotten the message about the importance of off-channel communication. The industry already had the message a few years ago. There were already several platforms and utilities and vendors that were coming into the market in terms of providing registrants with technology solutions to manage multiple channels of communications. Because it has to be said at this point, we're past email, we're past texting, we're past WhatsApp. There are a constant stream of messaging applications that keep coming on the market. And there's only so much firms can do in terms of prohibiting their use, because the reality is the fact that there's multiple kinds of messaging applications is just how technology has evolved and how people in our society communicate.
Yeah. No, and I think the point, Valerie, on technology is a really great one. Is even now, obviously the hot topic of the day is artificial intelligence. So, now we have these AI chatbots, how are those records being kept? AI use for, meeting purposes. So yeah, I think that technology piece is really important because as you said, even over the last 2, 3, 5 years, the technology has grown exponentially, both on the compliance side, but also on the communication side.
I think that's exactly right. And also, firms have been working towards finding ways to capture all of these various off channel communications. I think a few years ago, there was still the thought of, well, maybe we can keep it to email and text and WhatsApp. And now there's just this resignation that prohibiting all communications other than email and text is arduous and frankly not business friendly. Because the reality is, business communications have moved beyond email across society. This is not just something in the financial services industry, this is across the board. I was reading Commissioner Peirce and Commissioner Uyeda's dissent, or statement rather, called A Catalyst from September 24th. And they made several points about how this is also about client expectations. There's a point in that statement that says client service imperatives drive how firms communicate with their clients. You'll have a client who is also a neighbor. Maybe they do want to use a WhatsApp platform in order to get advice on both their investment portfolio and their garden. That's just sort of the reality of the society we live in. And the idea that these types of off channel communications should be prohibited is just not realistic. I know that there are still firms who are taking the position of prohibiting them, but I think they're increasingly in the minority. I think most firms are really trying to find a way through to compliance and to manage their risk, both through the use of technology and training and other ways to work at this issue.
Yeah, and Valerie, that's another great point. I think that prohibition stance, you're basically proving that negative, right? If you're monitoring, if you don't see anything, well, that's great. But, what if it was off channel and maybe you aren't able to capture those records? So, yeah, I think the strict prohibitions, I think, do put firms in an interesting position. And you're absolutely right, too, about the client centric approach. I know a lot of firms, necessarily wouldn't decide, hey, we're going to go out and text our clients. The clients text them, or hey, we're going to go out and use WhatsApp with our clients. The clients say, hey, would you be okay utilizing this communications platform? So I think those pieces, that client centric, but also I think it is getting more and more difficult now for firms just to have a strict prohibition, especially, how do you monitor that going forward? I think that could be an issue for some firms.
I think that's right. And then the other thing we need to remember here is, we're talking about 100 settlements. The majority of them were not about client communication. The majority of them had a C-suite element. And William, I was hoping you could talk a little bit more about that.
Yeah, so I think that, what we've seen, I think you're absolutely right. A lot of the communications were more to the executive level. So, when we hear about this concept of tone from the top, you do think that the SEC may get nervous and say, hey, if your top executives, if your management staff is doing this, kind of what's the supervision of their teams and how is that filtering throughout the organization. So, I think that tone from the top is really important. And also, we have seen, that failure to supervise. The SEC can not only bring maybe a books and records violation, they can also bring a separate failure to supervise charge as well, knowing that the people that are supposed to be supervising the staff are themselves engaging in this conduct.
And then there's also the issue, which happened especially in the early settlements, that part of how the staff uncovered that there was off channel communication is that they were seeking certain communication in the context of an unrelated investigation. And those records did not exist because they had not been retained by the firms.
Yeah, and I think that's also a great point because another thing we've heard too is that the SEC, and viewing some of these cases, while it is potentially a record keeping violation, again, a lot of these are, settled cases, but they also see it, as potentially an obstruction, saying, hey, we are here to examine you, but we don't necessarily have those records, which we feel like could be used in our examination process.
And that's exactly right. And, we hear about how records did not exist within the context of an enforcement investigation, but there's also the concern that this could come up in the examination context. So as we're looking at the settlements to date, some of the commonalities we're seeing are not just that not all records were maintained, but also the fact that it turned out some of these records were actually important in an exam or enforcement context. We're seeing C-suite, what we call sort of the shorthand is C-suite texting, meaning that the executive suite is similarly taking communications off channel, which takes away at the credibility of the entire firm and compliance program. Because if the leadership is texting or using texting as sort of shorthand for using an off channel communication, then what does that mean for the rest of the firm, right? And then furthermore, another element that we've seen is just firms that have policies and procedures that say one thing and then they're not following those policies and procedures, which, William, you touched on, I think, a little bit earlier.
Yeah, and I think that's a really important point is that, while the Advisors Act may have certain enumerated categories for record keeping, I mean, the SEC is going to look at your policies and procedures and say, look, did you follow the stated policies and procedures? Do you have a strict prohibition on, non-firm electronic communication or off-channel communication, as we've been talking about? I think to your other point, Valerie, too, is how far does that have to go, right? So we had already talked a little bit about, personal relationships versus relationships as a client of the firm. Some of the orders that we've seen, did talk about, hey, the SEC is looking at why didn't you access employees' personal devices to make sure you were complying with these policies. So again, I think one of the issues we've seen is, how far does that extend?
There's also a privacy implication here. This is really about ensuring that employees slash associated persons slash independent contractors of broker dealers and investment advisors. Obviously, this is all very business model dependent, but it's really about ensuring that all of these individuals are in compliance with firm policies, but that these firm policies take into account privacy concerns. So you can have a great set of policies and procedures. You can also have a great firm surveillance system, but how far do you go, right? Do you need to go all the way into your employees' personal devices? I would take the position that no, you shouldn't, especially because it will cause so much disruption in your business to try to implement that. But there needs to be a way to monitor off and on channel communications without being offensive to individual privacy.
Yeah, absolutely. And I think that's always going to be a struggle for firms. And I know that, Valerie, you had mentioned a few of those more recent cases. I'd love to hear your thoughts, especially, on how far firms do have to go, because I feel like, some of the more recent matters the firms did try to be more proactive. But I was wondering if you could talk about some of those more recent cases and kind of what we can glean from those as far as what a firm should or must do to kind of avoid these situations.
Absolutely. And I would really encourage everyone listening to us to take a look at the two off channel settlements for September 23rd and 24th that did not have a civil penalty, because they are both instructive and concerning. And I say this because there was one firm that as early as 2008 was working towards getting its arms effectively, I will add, the off channel communication issue. As early as 2008, personnel was advised that the use of unapproved electronic communications methods was not permitted, that they should not use personal email chats or text messaging. This is 2008. Let's think about what was happening in 2008. First, there was a financial crisis. Second, folks largely used email, BlackBerry messaging, and texting. I'm not sure WhatsApp existed back then. Skype messaging existed. So the fact that this firm was already looking ahead and reinforced its policies at least annually, had training, had reinforcement from compliance and senior management, and were even specifically advised not to list personal phone numbers and email signatures is really commendable. Because we're talking, this is 16 years ago, and this firm was already looking ahead. And what I find really instructive about this order is listed throughout the order are all of the steps that the firm took. And for every single step, this firm was 2 to 5 years ahead of the industry. So, for example, in March 2017, this firm provided its personnel with a compliant text messaging process that could retain business communications. That is comparatively very early in context of the rest of the industry. For example, back in 2020, let's think about what was happening in 2020. It was the height of COVID. Off channel likely got worse during early 2020 when people were moving to work from home. The firm required all personnel to have a firm issued device on which to conduct business and encourage personnel to use the firm issued devices when communicating with both business and personal contacts. So this firm really did everything. They also updated their systems to capture Slack and LinkedIn. They trained employees, they monitored communications, they disciplined employees. And even with that, they did end up with an SEC settlement. Now, it's correct. They did not have a civil penalty. That's great news. But it's also concerning that the order for the settlement found that the firm had failed to implement a system reasonably expected to determine whether all personnel, including supervisors, were following the firm's policies and procedures. And really, what the order is getting at is that the firm failed to implement sufficient monitoring to ensure that its record keeping and communication policies and procedures were always being followed. And I think this is the part that I'm really struggling with. It's the use of the word always in an order for a settlement where the firm is being held out as having self-reported, cooperated, done a lot of things. I can tell you this firm spent a lot of money, time, and deliberate thinking over the course of 16 years to avoid having an off-channel problem. And the only thing that this firm managed to avoid was having a civil penalty. And they still ended up with a settlement. Yes, they got credit for cooperation and self-reporting and all of that, and those are all good things. But how is it possible to always, again, the word always is being used in the order. And I'm a big believer in the fact that there's a reasonableness standard across the securities laws. There's never the expectation that things must always be perfect. It's the expectation that there are reasonable policies and procedures to reasonably catch certain behaviors. And that order, unfortunately, kind of lost sight of that. And that's what concerns me, because on one hand, you have this blueprint of how to be a firm that is doing the right thing. And everything in that order are practices I have advised clients to do to limit their off-channel risk. And yet, that wasn't enough.
Yeah, and Valerie, I completely agree. And what's also concerning, in addition to what you've talked about, is the order's really silent on what more they could have done or should have done. They didn't really say, oh, well, we do see all this proactive monitoring and training and, updating the policies, but it's silent on, what more could have been expected. And I think your point to the perfection versus reasonableness is a good one because again, the silence on, what would have met the standard in this case, I think is speaks volumes.
It really does. And it is concerning. So, where does that leave us at this point? I think everyone in the industry knows that off channel is a concern and that firms need to be devoting resources to managing their off channel risk and ensuring that they are maintaining records. Beyond that, and putting aside the perfection standard instead of the reasonableness standard, because I do believe that perfection standard is unreasonable. Putting that aside, I think firms can only continue to keep doing what they're doing to improve, but I think they need to be swift in identifying lack of compliance with off channel communications and record retention and also surveilling for it. And that's very business model dependent too, right? So if you have a firm that largely does retail business, off channel communication could be more of a risk for you than a certain other type of business model. Not necessarily, but perhaps. So you have to think of it in terms of those parameters. You have to think of it in terms of culturally, did employees use texting a lot? Did they not use texting? Did they use WhatsApp? It's also just for in-house legal and compliance to really understand the off-channel risk profile of their firm. And if there is a violation of policies and procedures, to do swift remediation. And this is really where bringing in outside counsel, bringing in outside experts can be helpful in telling the story of how the firm is remediating an issue.
Yeah, no, and I think that's absolutely right. I think some focus areas for firms just based on the settlement orders, supervisory and compliance policies, procedures, training, surveillance, technology. And I know something that you'd also talked about, discipline for non-compliance. Again, you're not going to be perfect, but if you want to, really keep meeting that reasonable standard like we think most firms do, I think those are some of the areas that you can focus on.
I think that's right, especially, and I will say, unfortunately, the disciplining aspect. And also training once a year is often not enough. And I'm not saying that from a regulatory interpretive standpoint. I'm just saying that from a human standpoint. It's not just about training anymore. It's about training and reinforcing that training and also following up so that if there is a violation of a policy, that there is also disciplining, because that's how you hardwire a program for anything. It's not just for off channel, it's just more generally.
Yeah, and I think that's absolutely right, Valerie. In the training, I think it was Brent Franklin that said, tell me and I forget, teach me and I remember, but involve me and I learn. So I think, you really need to have your staff be more involved in those ongoing trainings, really reinforcing, as you said, your compliance policies and procedures, but really just, doing the right thing. And if there's ever a question, reaching out to your compliance department.
So, William, we've been chatting for about 25, 30 minutes on this topic. I don't think we'll be able to resolve everything today. And I do think this is a topic we'll return to in a future episode. We're recording this in mid-October, and the episode is coming out on October 23rd. And of course, we're all looking ahead to the election. Our next episode will be after the election. We're, of course, all looking ahead to the impact of the election on the work that we do, whether we are, at an outside law firm, at a trade association, in-house in compliance, in-house in legal, or another stakeholder in the industry. So our goal with our next episode is to start taking a sort of post-election look at what's next. William, is there anything else that we should cover before we sign off?
Not for today, Valerie, but yeah, completely agree. I think this is an issue that's going to be sticking around, unfortunately. But yeah, I am really excited. Next month's episode, so many things happening in the political world, so it should be a really interesting one.
Well, thank you again. Until next time.